Alrighty, law nerds, this is Professor Tracy back with another video, and this one is on duress and undue influence. So we are building out our list of defenses and excuses. So let's get right to it. So remember our overarching framework here. We have been looking at formation for a long time. That's what we were looking at. And we've started into just recently looking at defenses. And we will be looking at these other categories moving forward. So looking at interpretations or establishing what are the terms of the contract and what do they mean, and then looking at breach of the contract and then remedy. What is it that someone can get as a remedy when a contract is breached? So we've been focused in now on defenses, and in particular defenses to formation, but we will also be looking at excuses to performance in a bit after we finish up all of our defenses to formation. So with defenses to formation, we started with a look at the statute of frauds, and we said, although it's certainly something you want to be thinking about at formation, about whether or not the contract should be memorialized in some sort of writing or evidenced by some sort of writing, it functions as a defense. If it's not complied with, if it's violated, then it will serve as a defense to the defendant. And our last lesson, we looked at incapacity or lack of capacity, meaning that the person does not have the legal ability, legal capacity to enter into an agreement. And today, we're adding in two more defenses. We're looking at duress and undue influence. So both of these are related to coercion or pressuring one party pressuring the other party into the agreement. So let's start with duress. With duress, we want to look and say first that we're going to look at two different kinds of duress. We're going to look at physical duress, which is when there is a threat of physical violence, which is kind of maybe the stereotypical thing that someone might think of when you think of duress, about, a knife to the throat, a gun to the head, that kind of thing, of sort of physical violence being threatened, and that being what is pressuring the other person to assent to the agreement. But there's also economic duress, when there is economic pressure being put on the other party through the use of an improper threat. And it's that threat of economic pressure or harm that is pushing them to enter into an agreement that is ultimately detrimental to them. So we're going to look at both, but our broad definition here, or rule, is this: that when a party's manifestation of assent, meaning their acceptance, is induced by an improper threat by the other party that leaves the victim no reasonable alternative but to agree to the contract is voidable by the victim of that threat. So we're going to break that up into elements. So we can see that it breaks down into three elements: that there's inducement, that the victim, so the offeree, is typically going to be the victim, since it is the assent or the acceptance that we have in view here that's being induced by the threat. So we have inducement, the victim's being induced to enter the agreement by an improper threat, and we're going to define each of these, and that threat leaves them no reasonable alternative. So in essence, this third element of no reasonable alternative is getting to what is the legally required in terms of the gravity of the threat. How significant must it be? And that's what that third element gets to. So let's look at inducement. Inducement, at its simplest form, is about this second box I have up here, which is that it's about causation. We're asking, was this in fact why the victim, the alleged victim of the improper threat, or why the offeree assented is this really the but-for cause that pushed them to enter into the agreement? And then when we're asking about whether or not the person was induced, right, whether the improper threat is what induced them into the agreement, then we also need to look and say, okay, by what standard are we looking at this, right? Or do we just say, well, it's satisfied no matter what? No matter what, if it caused the person to be induced? And the answer is kind of, because we use a subjective standard. The whole question of the gravity of the threat, the significance of it, we're leaving for that third element of no reasonable alternative. Because here with inducement, while historically there might have been a use of a more objective standard, we're just going to ask, was this particular person's will overcome by this improper threat such that that is what pushed them into the agreement? That's what induced them into the agreement. And what do we mean then by an improper threat? An improper threat. Well, there's a few different things that the restatement lists for us. It says that it could be something like a crime or a tort, or the threat of a crime or a tort, which is, now, a tort doesn't exclusively, or neither does a crime for that matter, exclusively have to be about physical violence, but certainly some sort of threat of physical violence or harm to property or taking of property would fit in under here, right? Those kinds of things that we might think of as, oh yes, those are certainly improper threats. Those are going to be here, right? Is it a crime or is it a tort? Is it the person's doing that, carrying that out? And unless the person does it, they're threatening to carry out something like that, that would be an improper threat. The other thing, and this one may be a little counterintuitive because it's hard to see, well, why is it that if you threaten to have somebody criminally prosecuted, that would be considered an improper threat? And the idea is this, like the kind of scenario you want to have in your head is, let's say that there's a company that they find out somebody's been embezzling money, right? Taking money, they've been dealing with accounts and they've been siphoning that money, embezzling it to themselves. That comes to light. And then what that person is told by their boss is something along these lines, that if you do not repay that money, then I will have you criminally prosecuted. And again, you might say, okay, that sounds like a reasonable thing to say. The concern is that if something is a crime, then the purpose of criminal law is a public purpose, right? It's a public purpose that it serves the public good. If that person has violated the law, we don't want it dealt with privately, nor do we want that threat of criminal prosecution to just be used as a tool for the company to get what it is that it wants. And then if it has the money repaid and then they quietly let the person go, they can kind of bury the whole scenario. It never comes to light. That we view as being an improper threat because a crime is an offense against the public, right? Against the public good. It is something that should be dealt with publicly. It should be aired out and prosecuted for the public good. And that's why the use of a threat of criminal prosecution to get somebody to agree, whatever it is, right? Agree that you're going to repay the money and that we are then going to have you quietly go away and you need to release us from any responsibility to pay you any sort of severance or whatever it may be, right? Pressuring that person in that way. That's what's in view there. Then a threat of a bad faith lawsuit. Here, what's in view is really a use of civil process, and the threat of a civil lawsuit when that lawsuit is either being threatened in bad faith, meaning you actually don't have a basis for it, or that you're making that threat not because you really intend to bring a lawsuit because it needs to be brought, but because you know that you can threaten that person in such a way to say it's going to be really expensive, litigation's costly, that kind of thing. That again, your goal there is to threaten them, to get them to enter into a contract. And you may not, right? It may be something where you're like, I wouldn't really do it, but if I threaten it, then I can get what I want that way. So it's the bad faith use then of civil process. And then the final one here is a breach of the duty of good faith and fair dealing. So what you're threatening there often, particularly in for instance, a economic duress situation, and we'll look at more detail at economic duress, but in a situation like that, often the kind of threat in view is saying, I'm not going to perform in the contract we already have unless you agree to enter into this other agreement at terms that are very advantageous to me. I know you're in a difficult spot, and I know that I can threaten not to perform, right? To deprive you of the benefit of the contract, to breach the contract, to breach the implied obligation of good faith and fair dealing, in order to try to force you to agree to something else I want, some other contract that I want. And we'll see an example of that in just a second. So those are the categories of improper threats that were given by the restatement. And you could, I guess, analytically really put improper threat first and say, was an improper threat made? And then did that improper threat induce the victim to assent to the offer, to the contract? And when we're looking at the threat, we're asking, was there no reasonable alternative? No reasonable alternative. And that's getting at, again, we said the gravity of the threat, what's required. Because when we're talking about inducement, we said it's largely just a question of causation. And when we're asking, was the threat what induced the person, we're focused on, well, was that the cause? Was their will overcome such that they felt compelled to enter into the agreement? Not, would a reasonable person do it, but was their will? But this, when we say no reasonable alternative, now we're beginning to look more particularly and say, okay, but how big of a deal is this threat that's being made? Did this party, the victim, did they really have no reasonable alternative? And the answer is, we're going to look, when we say reasonable, just like in most circumstances, when we say reasonable, we mean we're judging by all the facts and the circumstances and looking at what are the options available to the person, why, what is it, what are the pressures that are on them such that they folded and assented to this. And when you think about litigation, right? What we can't say is, well, every single time you don't have to agree. You can just sue. You always have a reasonable alternative. You can always pursue legal action. And the answer is, well, no, it's not a reasonable alternative if the party is going to face immediate and irreparable loss, for instance, to one's economic interest. Obviously, if it's a gun to the head, it would not be an economic interest, but to your well-being, your life, and you do not have another alternative. That would be the clearest idea of like, well, there's no other place to go here. So when we're looking here, we're getting at the whole circumstance, and it's telling us in the circumstances, how significant is this threat? Did the party have some other option under the circumstances such that they didn't have to give in? And because we don't want everything to be able to fall into under the heading of duress. And we'll talk about this more when we look at undue influence, but it's important to understand that some level of negotiation and bargaining, sometimes even hard bargaining, is part of doing business. And so we're not trying to establish defenses that cut out that possibility. We need to try to account for that in the way that we apply our defenses, in the way that we understand them and define our terms, and in the way that they're being applied. So duress, we said we have physical duress, we have economic duress. So let's look at physical duress in detail. What do we mean? If there is actual physical duress, then the contract is considered void. It is void, meaning that the victim does not have an option to affirm it. The contract is void from the beginning, meaning it's not voidable, such as, for instance, when we looked at lack of capacity, it was there, the party that lacked capacity had the option to disaffirm, but they could ratify. Here, if there is physical duress, there is a threat of physical harm, or the person's arm is, for instance, being physically moved to do it, then we view that as being void. That it's not capable then of being affirmed, even if the party wants to do it. Because we're saying from the beginning, it was not a valid agreement because the assent wasn't voluntary and the acceptance was not in fact an acceptance. Then, so that ties into the second thing, which is it can't be ratified, right? That if it's void, you can't possibly ratify it. So then let's look at an example here. Bo, please sell me your house for $100,000.
No way. It's worth at least 3 times that. Besides, it's not for sale. I'm not moving anywhere.
I tried asking you nicely, and you wouldn't agree. So I'll try again. Sell me your house for $100,000 or else.
Or else what?
Stop stalling. Death, Bo. Death. That's your alternative.
Okay. Just put the gun away. I'll sell you my house for $100,000.
So both they enter. So sorry to be grim, but I'm trying to give just a clear-cut example of what we think of when we think of physical duress. So here we have a threat to that Barb's threatening to shoot Bob, and here he agrees, right? And if we sort of cycle back through, right, that it started with Barb made an offer. Right? She made an offer. He's not interested, right? But then she makes a threat now, saying she reasserts her offer with a threat, right? Improper threat. Then there's no alternative, right? He has no reasonable alternative, or else what? Well, the alternative is death, right? So he's induced. He's induced into the agreement. It pushes him in, right? That's the cause of him agreeing. He didn't want to sell his house, so he's promising to give her the deed to the house. She's promising to pay the $100,000. That's the offer, the bargain she laid out in her offer, and he has accepted that. Now he performs, right? Gives her the warranty deed for the house. She pays the $100,000. And voila. Now, after that's done and he's safe, he is now seeking to disaffirm. He's suing to disaffirm the contract based on a defense of duress. And so, assuming all those elements are met, as we just claimed that they were, that he could show, right, that the 3 primary elements are met, that there was an improper threat. That part's pretty straightforward here. That it fits in our first category, right? That it's a threat of a crime or a tort, and this is also a situation then where he's induced, right? The cause of him doing this is the threat. And he didn't have a reasonable alternative, right? Because she was holding a gun. He was at risk of death or serious bodily harm if he didn't just agree. So he agreed. So he seems to be able to make those out. If he can, then remember the contract is void. We're calling it a void contract, as the title there shows on the screen. So there, the contract is considered void. Nobody... Bo would not be able to affirm it if he wanted to, right? It can't be ratified. So what about economic duress? Economic duress there's a little more nuance to it, as you would expect, right? The typical fact pattern is something like this, although to be fair, my example that I'm about to give us doesn't fit exactly this one, but this kind of situation is common, right? I guess it is similar, I think, in some ways. But here, what I'm suggesting the typical fact pattern is let's say somebody owes the other, there's two parties, they have an existing contract, and one of the parties has yet to make the full payment for, say, whatever service is to be provided. So if you've read cases like Totem Barge or the Rich Willick case, those are about services, one about things being transported on a barge, another about excavation work being done. And in each case, the party that is going to be paying knows the party that provided the service is in a difficult financial spot, and so approaches them and says, hey, agree to accept less, or who knows when we'll pay, right? Agree to accept less, or we may or may not ever pay. So they're trying to pressure them because they know they're in a difficult financial spot. So, and here with economic duress, it's not void, it's voidable, just like lack of capacity. So it's voidable at the option of the victim of the duress. So, which means, keep in mind, that means that they could just affirm the contract or ratify it and move forward, and if they're okay with it. So here's what I was saying, that assume there's an existing contract between the parties, right? Like this one. Herman, we're going to assume here that Bob is running some sort of like a chocolate shop or a business where he is selling foods, including chocolates, and Herman sells chocolates. So Herman there's a contract between Bob and Herman's promised to give him 1,000 boxes of chocolates, and Bob is going to pay him $3,000 for those boxes. And then Herman says, I know you need those chocolates from the holidays. I'm only going to deliver them if you agree to buy 5,000 boxes of chocolates next year. So here, rather than the obligation being about money, it's about Bob's need for chocolates, right? For chocolates for the holidays, to have them in stock, and Herman's his source for those. And he knows that Bob is dependent on him. So he's saying, you know what? I'm not going to deliver those unless you agree to buy 5 times as many for next year. Now that, he has no alternative, right? So there was a threat made. Herman gave us the threat there, and he leaves no alternative, which is what? I really need those chocolates you promised for this year. I don't have any other source to get them from, especially given the time. And then inducement, fine. I agree to buy 5,000 boxes of chocolates from you next year. Just send me the 1,000 I need for this year. So we have this second contract that he's been induced into, right? This is the one for next year, that Bob's promising to buy 5,000 chocolates, and obviously Herman's going to do them. I didn't bother to put in a price there. So the first contract, then Herman says, well, you agreed to what I wanted, so he's going to perform. He's going to give him the 1,000 boxes of chocolates. So he gives him that. Right? And here then, after Bob has those, Bob's going to sue to try to disaffirm that second agreement he just entered into, the one for the 5,000 boxes of chocolates for next year. He's going to use the argument of duress, and it's not a threat of physical harm here, it's economic, right? That he needs this for his business and that he's dependent on it. And if he can show those things, then he would be able to disaffirm it based on duress. So that's what economic duress looks like. So that's duress. We looked at physical duress, Economic duress, obviously the elements are the same, but the way they play out is slightly different, and physical duress being void and economic duress being voidable. So what about undue influence? So undue influence is waning in its significance because of the fact that as duress has been expanded to things like economic duress, the need for something like undue influence is waning. It's waning, and there's also, I think, a problem with undue influence of it's harder to cabin in some ways, right? You are potentially beginning to tread on what are normal negotiation bargaining tactics with this. And I brought that up with duress, but it's even more of a concern, I think, with undue influence. So what we say with undue influence is at a basic level, there's kind of two parts to it. That it is unfair or excessive persuasion, right? One party, rather than an improper threat, right? There's not an improper threat because we're under, that's duress, but undue influence, we have unfair or excessive persuasion. And then we have somebody who's susceptible to that excessive persuasion. And generally they're described as being in a weaker position, that the person doing the excessive persuasion is generally considered to be in a more dominant or position, to have some sort of authority or power over the other person, and the susceptible person, the person being persuaded, we require that there's some weakness of mind or will. And so you'll see it written out something like this, although the elements are going to be more specific than this, or more extensive, I should say. It says it's the use of excessive pressure to persuade one vulnerable to such pressure to enter a contract that is against their best interest. And so we generally look at that in four elements, and that's how the restatement looks at it. It says there's, again, inducement, and this makes sense that there's got to be causation, that the excessive or unfair persuasion is what is causing the person to assent. So there's still inducement, and again, you could analytically think of that as being probably second, that we first want to find that there is some sort of unfair persuasion going on. But nonetheless, I'm putting them in the order that they often are listed, even if analytically it may make sense to say, well, let's have unfair persuasion. Then we can say, did that unfair persuasion induce or cause the victim to assent? And the victim has to be someone who is unduly susceptible to the other party, right? To being dominated or persuaded by the other party. And then the result must be inequitable. It must be an inequitable result. Not just that they regret it later, but in fact, inequitable. And we'll talk about, well, how do we decide if the resulting contract is actually inequitable? And we'll look at the factors that the restatement gives us for that. So we have inducement. It's going to work the same as we said before, that in terms of just straight up inducement, we're asking about causation, and we're just asking, is this unfair persuasion or undue persuasion or excessive persuasion, is that what caused the person to assent? So with unfair persuasion, here, I think it's really helpful if you've read the Odorizzi case, which is about the school teacher who signs a resignation because of his arrest, and the court goes in and lists the kinds of factors that should be considered when we're looking for unfair persuasion. So these are the kinds of things that would constitute unfair persuasion. But let it be said, these are just the court's list of, here are the kinds of things. There could be other things, but I think these are helpful things to think about, right? Unusual and inappropriate time, meaning if there's a conversation happening about entering into a contract, is it an unusual or an inappropriate time? Is it an unusual place? Is it an insistent demand that business be finished at once? Meaning it's got to be done now. And often that is coupled with the next one, which is, and that when you're saying it's got to be finished now, you're saying, well, and if it's not, here's the horrible thing that will happen. Here's the horrible consequences of delay. And sometimes you will find that there are multiple people that show up to negotiate something, to pressure the other party, right? That you have multiple people on your side. You don't need that, but that could be another thing, and that would make someone more dominant, so to speak, because you have multiple people pressuring one person. Then the absence of third-party advisors to the servient party, meaning that whoever is being pressured, do they have anybody with them? Do they have an attorney? Do they have an accountant? Do they just have somebody there, like a friend or a coworker or a colleague, someone to be their advocate, and depending on the situation? And this is, I think, similar, right? This one is similar to these, right? But a kind of a particular form of that, which is to say, we need to finish now. If we don't finish business now, this is what's going to happen. And also that there's no time. If the person says, but I want to talk to my financial advisor or my accountant or my attorney. No time. We've got to do it now. Those kinds of things are unfair persuasion. So undue susceptibility. Well, how do we know if somebody is unduly susceptible to undue influence? How do we know that? So here, well, generally courts will talk about one of two things, and perhaps both, but you don't need both. So you could have a weakness of mind, and meaning that, and there, it could be something like mental incompetence, but it doesn't have to be, right? We're not requiring somebody to prove mental incompetence, because if they could prove mental incompetence, then they wouldn't need undue influence, right, as a defense. But here, that certainly, if you are in a position where you are suffering emotionally or mentally, physically, maybe because of events that have occurred, because of sickness, because of other things, then that is an indication that you are in a susceptible position, because you're run down, you're worn out, you're not mentally in a good place, you're emotionally drained, whatever it is. That means you're more likely to be pressured, right, and malleable. So the other thing you will see when we talk about there being a servient party and a dominant party, and the dominant parties is pressuring the servient party, there is often a relationship of trust or dependence. You'll see it described sometimes as just, quote, special relationship. But I think generally the ones that are listed here, I would say, do fall under the heading of, quote, special relationship, but they don't have to necessarily. The relationship could be just one of trust or dependence. So, for instance, just think, for instance, like if you are have been admitted to the hospital, then there, even if we're not talking about your doctor being there, you are still in a relationship of trust. You are dependent on the nurses there for your care, right? And if you are, even if you are in your own home and very sick and someone's taking care of you, the same thing, right? Regardless of whether they're actually a doctor, that kind of thing, there could still be dependence. And sometimes the one thing to think about too would be, let's say you inherit a business, a family business, and you don't have a lot of experience, and say you inherit it after your mother passed away, and you inherit that business, you're taking it over, and you're relying on some of the other people in that business, in order to make wise decisions about how to run it. There too, even though there may not be any formal special relationship, they are aware and you are aware that in many ways you are dependent on them because of the circumstance. They are the experts, they have knowledge, and although you now own the business and are running it, you don't know everything. And so you are in a position where you are unduly susceptible to being pressured by them. So what about an inequitable result? We said the restatement gives us a look at this, right? It says, here are the factors, right? It says to consider these factors because if the resulting contract is fine, it's fair, then okay, maybe it wasn't a great situation, but in the end, no harm, no foul, right? So what we're looking and saying are, what are the economic consequences? That's probably the most obvious, like, oh, yeah, of course, is it very one-sided? So divergence from prior course, there, what the restatement's getting at is saying, like, if the victim appeared to have one course and then all of a sudden changed their mind after talking to this person, that's an indication that the result's not quite right here, right? That they were diverted. So an inequity in value of exchange, so that whatever is being exchanged kind of, in many ways tied closely, certainly not tied, but closely related to number one. And then the appropriateness of any change in light of the length and the nature of relationship. So there, if the change was made at the request of somebody, like a change to a contract or business relationship, and one of the ways we might judge that is to say, well, does that make sense in light of the fact that you just met the person, you've not known them at all, and now you're just catering to their whims? So those are the things the restatement tells us to look at. So let's look at an example here. So Bob is sick. Okay, Bob is sick. That's my attempt to make Bob look sick. So thanks for taking care of me while I'm sick, Bo. I don't know what I'd do without you. I feel terrible. So here, now Bo shows up in the bathroom, right? Bob is trying to clean up, get in the tub. He's not feeling well. He's like,
Bob, there you are. You know how I've been asking about your car?
What? Wait, how are you in the bathroom with me? Why are you in the bathroom with me?
Oh, I'm fine. I don't mind being in the bathroom with you. How about $800 for the car?
$800? I don't know. I feel terrible. I can't think straight. How about we maybe talk about it later?
Oh, I'm fine talking about it now. So how about $785 instead? Well, let's agree now, and then I'll get back to making you some soup for dinner, yo.
Fine, that works. I'm gonna finish my bath, have some of that soup, and then lie down. Ugh. Please, no more talking.
Of course, but just to confirm, we have a deal on the car, right?
Yes, we have a deal. Please go. So there, right? So Bo showed up in the bathroom, right? Is pressuring Bob, and now they're entering into this agreement, right? Bob is promising his car. I'm going to deliver my car to you, and Bo is saying, I'll pay you $785 for the car. So they have a contract. And now Bob, he's all better. Now Bob goes, I don't know why I agreed with Bob, but I'm certainly not going to sell my car. So Bob's saying, I'm not going to perform, right? I'm not going to perform. So he's breaching, right? Or he repudiated the agreement, but he's breached. And then Bo is suing him because he's not following through on their agreement. And then Bob raises his defense, right? Bob says, I have a defense against your breach of contract claim, which is undue influence, right? So he's raising it. And remember what he's got to show. He's saying, I was induced into this, right? So, well, let's start with well, we'll do them in order. So is there inducement? Was this the cause? Was his will overcome, right? He was pressured into it. Yes, right? That the facts are clear that was the cause, right? He wasn't thinking about selling his car. Apparently it's something maybe Bo had mentioned before, but it wasn't something they were talking about at the moment. And so he brings it up. Then we would say, is there unfair persuasion or undue persuasion or excessive persuasion? And here we have all those factors to think about. While there weren't multiple persuaders, there was certainly a situation where what? One, Bo is there. He is taking care of Bob. Bob is not feeling well. He said at the beginning of our example, he didn't know what he'd do without Bo. He needed Bo to take care of him. Bo was taking care of him. He was dependent on Bo in that way. And Bo barges into the bathroom and he starts, so it's not an appropriate place, not an appropriate time. And he will not let it go, right? He keeps insisting and trying to confirm it. And he twists every time Bob is saying something. Bo acts like, oh, no, I'm fine talking to you in the bathroom. Or I don't mind this or that. Like, just keep going, right? Just to confirm. And Bo keeps being insistent, right? So he meets that element. And we can look and say, yes, it is the case that Bob here is that he was susceptible, right? Because if we look, he had, quote, weakness of mind in the sense that he was sick, he wasn't feeling well, he wasn't thinking clearly, he was just tired and exhausted and felt like garbage. Then you could also say, although it's not a, quote, special relationship, it was a relationship of dependence or trust, in that Bob was dependent on Bo. And Bo, bringing up I'll make your dinner if you confirm all this for me, kind of thing, like hinting, not threatening, but just hinting that I am the one getting your dinner together, that kind of thing. So all of that looks like, yeah, Bob was susceptible. And then you would say, well, what about was the result inequitable? And I think this is an example of where it deviated from any prior course he had. He did not intend to sell his car, right? If you're saying, what was his prior course? To keep his car and not do anything else. Then he deviated from that. And Bo is like lowballing him. We don't know how much it's worth, but he gives one number and then he comes back already with less before Bob says anything. And so there is a situation where it appears to be inequitable. So assuming that is all true and Bob can successfully carry the burden, prove those elements, then the contract will be disaffirmed, right? It will serve as a defense. Had any money been paid or the car been given, we would have restitution, right? That Bo would have to give back Bob's car. If Bo had driven it, he would have to give money to account for any use or depreciation of that car. And then Bob would give back whatever money to Bo, but only if Bo had driven it, etc., or damaged it in some way, Bob doesn't have to give him back the money if the damage or the wear and tear is more than the money that was paid. So, but that's how it would unfold. So that's undue influence. So those are our defenses to formation, right? Our defense to formation. We've got 4 of them right now, and we'll keep building out that list as we go. And that's it for now. I do hope it's helpful. As always, please like and subscribe if you haven't already. I very, very much appreciate your support. Have a great day. Bye.